we'll get started now. That's my contact information. And let's talk about salaried exempt employees. We've talked about this morning that the Fair Labor Standards Act of 1938 is the basic federal wage and hour law in the United States. And the act establishes standards for minimum wage and overtime, as well as record keeping and child labor. Now, there are also a number of exemptions from one or more of the requirements. And some of those exemptions, quite frankly, are pretty weird. There is, for example, a complete minimum wage, overtime, and child labor exemption for home workers who make Christmas wreaths out of holly, pine, or other natural forest products. Why, you ask, would there be such an exemption? Because apparently many, many years ago, the Democrats needed the vote of Republican Senator Margaret Chase Smith of Maine in order to pass some wage and hour amendments. Evidently, there's lots of home workers in Maine who make Christmas wreaths. She didn't want them to have to worry about child labor or minimum wage or overtime rules, and this exemption was the price of her vote. It is said that you should never look too closely into how laws or sausages are made. But there is one exemption that is applicable in every type of business, and that's the one we're going to talk about today. That is the exemption for bona fide executive, administrative, and professional employees and outside salespeople. This is often called the white-collar exemption, back from the old days when in the factory the hourly workers all wore blue work shirts and the managers all wore white shirts and ties. So it's the white-collar exemption. Now, the starting place here is that you can't make someone exempt merely by paying them on a salary. I can put the janitor on salary, call him the president, but as long as his primary duty remains sweeping the floor, he is not an exempt employee. And titles don't matter. Whether I call you a secretary or an administrative assistant doesn't make any difference. What determines your exempt eligibility is your duties. So, there are elaborate regulations at Title 29 of the Code of Federal Regulations, Part 541, which define the terms executive, administrative, professional, and outside sales. And keep in mind, the rule of thumb is construe the exemption narrowly. If it's borderline, if it's questionable, it's better to classify the employee as non-exempt and pay them overtime. Nobody's ever going to get in trouble for being paid overtime. It's when you don't pay them overtime and the Department of Labor or a court says you shoulda that you have problems. So, the Bible on this is Reg 541, and when you classify employees, that's what you refer to. All right. As I've already basically stated, exemption requires that you meet two types of tests. There's a salary test, and there are some duties tests. Now, each of the four categories has different duties tests. You have to meet all the duties tests in a particular category to be exempt, but you don't have to meet all of them in all categories to be exempt. So if you're an executive, we apply that set of tests. If you're an outside salesperson, that set of tests, and so on. And you have to be paid on a salary basis. Now, the salary basis of payment involves both an amount of money and a method of payment. There are limitations to the circumstances under which you can dock the salary of an otherwise exempt employee. Now let's talk a moment about state law. Most states that even have overtime laws, and of course Texas does not. So in Texas, we follow just the feds. Other states have their own overtime laws. They all have some version of this exemption. But some of them vary a little bit. Most of the variations are going to be things like they have a higher salary requirement than the feds. But when you get into California, again, show of hands, how many of you have branches in California? Yeah, all right. When you get into California, you have substantially different set of requirements. And just because you're complying with the federal law in California doesn't mean that you're off the hook. You need to be familiar with the state law there and in every state in which you operate, to be sure that you comply both with the state and federal rules. And as I said this morning, the rule, pardon me, the rule of thumb is whatever is more protective of the employee, that's what you got to apply. Okay, minimum salary for exemption is $455 a week, or $23,660 a year. I think almost everybody knows that in 2016 they were going to raise that. The set of regulations were adopted that increased the minimum salary to $913 a week, or $47,476, effective 12/1/16. On November 22nd, however, Judge Amos Mazant of the Northern District of Texas, actually it's the Eastern District up in Sherman, Judge Mazant issued a nationwide injunction that prohibited those regulations from going into effect, basically froze the regs. Now, there's a lot of backstory on this, and some of it's pretty interesting, but I don't know that it's interesting to anyone but lawyers. But there were a group of plaintiffs' lawyers, very well-known national plaintiffs' employment lawyers, who took the position that the injunction did not apply to private litigation, only to action by the Department of Labor. And these folks sued, I think it was a Chipotle in New Jersey. I don't know why they were in New Jersey. Maybe they were looking for what they thought was a favorable forum. But in any event, this cheesed Judge Mazant off royally, who actually went after those lawyers and sanctioned them. So their sanctions are now on appeal. So anyway, it was pretty serious stuff. Now, this happens in November, after the election, but before the change in administrations. The Obama administration applies to the Fifth Circuit. They file an appeal, but of course these things move slowly, and by the time it gets to the Fifth Circuit, there's a new president and a new Labor Department. And the new Labor Department decided not to pursue the appeal. Essentially, they told the Fifth Circuit, look, don't worry about this. We'll come up with some additional regulations later. And so essentially, it died at the Fifth Circuit. So unless and until the current Department of Labor issues new regulations increasing the salary test, we rock back to the old $455, $23,660 a year. Now, this was a little frustrating. I had clients who, being real good clients and proactive, actually increased a bunch of salaries, and I suspect some of you did the same thing. Reclassified some people as non-exempt, increased some salaries that were close, and then the whole thing just went away. So those are the realities. Anyway, now and until further notice, it's $455 a week. Okay, now, there is another level of compensation that should be mentioned. For many, many, many years, employers argued, look, isn't there some amount of money, however high, that if we pay this amount of money, we don't have to worry about whether they're exempt. You know, they're automatically exempt. And this is often called a bright line test. What's the bright line between exempt and non-exempt? Well, when these regs went into effect in 2004, the current ones, not the ones that were enjoined, the Department of Labor basically accepted that reasoning, though it wasn't entirely so. What they said was they would create a group of HCEs, highly compensated employees, who would almost automatically be exempt if their total annual non-discretionary compensation was at least $100,000 a year, and at least $455 a week of the total was paid in the form of a guaranteed salary. Now, what do we mean by non-discretionary? And a great example here is stockbrokers. You have a lot of stockbrokers who obviously are paid on commission. And the Department of Labor has always accepted that that job has exempt duties. But there have been some cases. There was I think it was UBS, had some brokers, and they wound up paying like $100 million in back pay and damages, because although some of these people made 6- and 7-figure compensation, they didn't guarantee them a base salary. So non-discretionary compensation means something like commission, where if you do it, you're compensated. You sell this much in stock, you're supposed to get this much in commission. It doesn't mean at the end of the quarter I just decide, hey, you've done a good job, here's $5,000 or $10,000. So if you've got an employee that is salaried at $455 a week or more and gets other non-discretionary compensation high enough to jack them up to $100,000 a year, that person is considered a highly compensated employee. And although they're not automatically exempt, they have to meet one duties test out of one or more of the categories. So it's pretty easy to be exempt. Okay, so that's the amount of money required. Basically $455 a week for highly compensated, $100,000 a year, $455 of which has to be in the form of a guaranteed salary. So let's now talk broadly about the salary basis of payment, the methodology. General rule number 1, subject to certain exceptions, and quite frankly there's a lot of exceptions, an exempt employee must receive the full salary for any week in which the employee performs any work without regard to the number of days or hours worked. Now that starts out sounding pretty strong. It winds up not being anywhere near that strong because there's a number of ways you can dock salaried exempt employees. But that's the first general principle. And the second general principle, exempt employees need not be paid for any work week in which they perform no work. I said this morning, the measuring stick for compliance with almost everything in the Fair Labor Standards Act is the work week. Work week, of course, is defined as a fixed and recurring period of 7 consecutive 24-hour days. Once you've established that work week, you have to live with it, and this is what you look at. So if you have employees who are exempt, and let's say they're in North Carolina right now, and their work week is Monday through Sunday, and they get sent home tomorrow, and they don't come back for 3 weeks, this week they draw their full salary, right? Because they've worked part of this week. Next work week, next Monday through Sunday, they've done no work. They've been sent home because of the weather. They don't have to be paid. So the principle is, if you're shutting the place down, if you shut it down for the entire work week, your employees don't have to be paid. If it's only for part of the work week, they do. Okay, now, let's talk about what some of these terms mean. We said that a salary is a predetermined amount of money constituting all or part of the employee's compensation. That predetermined amount is the floor under their wages. So if I tell you you make $500 a week plus commissions or plus bonuses, then that's perfectly okay as far as the law is concerned. There's no cap on compensation. The minimum compensation requirement is just that. It's a floor under wages. It's not a ceiling on top of wages. So if you manage a big retail store, big box store like a Walmart or a Costco or one of those, you may get $500 a week plus 1% of the gross, which is going to be far more than your base. But the base portion has to be a salary. And you can't count board, lodging, or other facilities toward the $455 a week. So if you have someone who is in a resort area, a manager of a resort, and that person gets to live on property in a palatial penthouse and gets to eat, and drink anything they want to, and they only get $400 a week, person is non-exempt. If they were a regular non-exempt employee, you could take credit toward minimum wage for that, but you can't take credit for board and lodging toward a salary. Okay. You cannot vary the salary according to the quality or quantity of work. Now, that's kind of a vague phrase, but what it effectively means is it forbids deductions for the employer's benefit. So, If you have an exempt employee traveling on company business and leaves the company laptop on the airplane, and it gets stolen, or if the exempt employee is driving the company car and wrecks it and there's a $500 deductible, you may not recover those amounts from the salary of exempt employees. If you do, you have retroactively rendered them non-exempt, and they can now come back and go after you for 2 years' worth of back overtime. So you don't want to do that. Now, you could get it out of bonuses, you could get it out of commissions, you could take it out of their paid time off. There's lots and lots of things you could do, subject, of course, to state wage payment laws, which often limit that or require consent. But under the FLSA, what's sacred is the base salary. And you cannot reduce that because of variations in quality or quantity of work performed. I was an expert witness years ago in a case involving Long John Silver's. It was an arbitration case out in San Francisco. I got to tell you, having to go testify in San Francisco is tough duty, but some of us have to do it anyway. And it was on a Friday, and shortly after I got off, Napa Valley and all those wineries were calling to me. But the issue in that arbitration was that when you went to work for Long John Silver's, you, as a manager, you had to sign a document. It was entitled Authorization to Withhold. And what that authorization said was that if you caused a monetary loss through your negligence, they would snatch that out of your salary. Now, we met more than cash register shortages. This is where, let's say, the manager at the end of the day counts up the money and is supposed to make the bank deposit. But it's late and it's raining and I don't want to go to the bank. So I put it in an envelope, I put it in a file drawer, thinking I'll make the deposit tomorrow. Well, somebody breaks in that night, finds the deposit and steals it. They would take that out of the manager's paycheck. That was a violation and they lost the case and had to pay, substantial back wages. Because by doing that, they made all their managers non-exempt. And as you know, managers of restaurants work long hours. So that's the kind of thing that you cannot take out of the compensation of an exempt employee. Now, let's talk about, that's docking the money. Let's talk about docking for absences. Now, under the wage and hour law, there's two broad categories of absences. There's absences caused by the employer or the operating requirements of the business on the one hand, and there's absences caused by the employee. So let's start with absences occasioned by the employer. And if it's occasioned by the employer, that's the regulatory language, we apply what I, for convenience, call the full work week rule. An employee is not paid on a salary basis, meaning they don't qualify for exemption, if deductions from the salary are made for absences occasioned by the employer or by the operating requirements of the business. Well, I already gave you one example of that, didn't I? The hurricane. That's an absence occasioned by the operating requirements of the business. Here in Houston, you had a whole bunch of that a few years ago when you had your hurricane. And a lot of businesses had to shut down and a lot of people got sent home. It would also apply in situations, for example, at a hospital where they tell the registered nurses that census is low, we don't need you, we're sending you home. That's an absence occasioned by the employer, and unless they send them home for the full week, they still have to be paid. Again, you can send them home for a full week, even if they don't want it, even if they fight you. But if I tell you, okay, our work week begins Monday, next Monday, for that entire work week, you're off. We're laying you off temporarily because demand is low. Or there was a strike and our manufacturing plant has to close because we can't get supplies or we can't ship our products, whatever it may be. If the employer or the operating requirements of the business cause exempt employees to miss time, they must be paid anyway unless they miss a full work week. So that's the full work week rule. What if the absence is caused by the employee? And there are, here again, everything breaks down into twos, right? There are two types of absence caused by the employee, personal and sick. So let's say that we have an employee who misses a day for personal reasons in the private sector. It's a little different in the public sector. In the private sector, deductions from pay may be made when an exempt employee is absent from work for one or more full days for personal reasons. One or more full days for personal reasons. Only full day absences can be docked. If an exempt employee is absent for, say, 1.5 days for personal reasons, the employer can deduct only for the one full day absence. So, I'm an exempt supervisor at your company. I wake up Friday morning. I look out the window. The sun is shining. The birds are singing. The fish are biting down at the lake, and I just don't want to come to work. You may dock me a full day's pay. Now, what's a full day? If I normally work 5 days a week, it's 1/5. If I normally work 6 days a week, it's 1/6. But you may dock my pay for that absence. However, let's say I wake up on that Friday, drag myself in, plop down in front of my computer, fire it up, start looking at my emails, and suddenly I realize work makes me tired. And so I go home. You must pay me for that day. Even though I only stayed for, a short period of time, I did some work. That was not a full day absence, and you got to pay me. Now, can you charge me vacation or PTO? Yes, you can. You may charge leave balances in increments of less than a full day. So if I come in, work half a day, go home, you can charge me a half a day's vacation. But if I'm out of vacation, you're out of luck. If I have no more leave balance and I miss a half day here and a half day there, you got to pay me, even though I don't have any paid time off or